International commercial arbitration is a private dispute resolution method where the parties give the arbitrators the power to resolve the dispute through a final and binding award. However, arbitration does not operate in a legal vacuum, as it is regulated by the following layers of laws. First, the law that determines the validity of the arbitration agreement. Second, the Lex Arbitri, or the procedural arbitration law. Third, the substantive law that the tribunal applies to the merit of the dispute. And fourth, the law governing the recognition and enforcement of the award issued by the tribunal. Let's have a quick look. Lex Arbitri is the law regulating the arbitration's proceeding, and it's usually the procedural law that applies at the seat of the arbitration, by drawing the exterior framework of the arbitration proceedings, as it deals with the following issues. The form and validity of the arbitration agreement, for example, the agreement must be in writing. The service of notice and exchange of pleadings. The arbitrability of the dispute, and whether the subject matter should go to court or to arbitration. Appointment and composition of the tribunal, and reasons to challenge an arbitrator. The tribunal authority to decide on its own jurisdiction. Due process and the equal treatment of the parties. Tribunal power to issue interim measures, and scope of the court assistance. The conduct of hearings and submission of evidence, like witnesses and experts' reports. The form and validity of an arbitration award, including the costs and when to challenge the award before the court of the seat. While Lex Arbitri safeguards the proper conduct of the arbitration, it does so without necessarily taking away the parties' freedom of organizing their arbitration as they wish, in particular that the parties and the arbitrators can amend or derogate from the provisions of the Lex Arbitri whenever the law permits so.